about your passion and your dedication to the civil rights of LGBTQIA plus people.
Sure.
You've been quite instrumental for a very, very long time. And we just want to know your story.
I'm an older gay, remember? So there's a lot of time there.
So we have this inside joke, right? So we're talking about our identities, right? And I said that Norman, was a white gay male. He's like, excuse me, older white gay male. I said, okay. You have been very passionate about making sure there is equality for, all people in those particular who are part of the heteronormative society, and just making sure that we are recognized, and our love is recognized. So let's just jump into it.
Sure.
Can you share your story?
Sure, absolutely. When I was coming out, it was a challenging time for gay people to come out. Thankfully, we've taken huge steps. And while there are so many challenges that young gay people face coming out today, particularly in certain parts of our country and our world that are not as progressive as things are, for example, here in New York, back then, sort of the standard baseline everywhere was that it was very hard to come out of the closet because you didn't really have a support system, you didn't really have role models for the most part. So having gone through that struggle, and then coming out and starting my career back in 1996 at a law firm, I knew that I A, wanted to be out of the workforce, and then B, wanted to do something with my law degree that could help other people like me to have a little bit of an easier time. So I remember in 1996 I went, but some of that's easier said than done. So still to be out in the workforce in 1996, even though I vowed to do it, actually doing it was hard. Just to digress for 1 minute, my firm is a firm called Kramer, Levine of Tallis and Frankel. And the Kramer in Kramer Levine is Arthur Kramer, who's the brother of Larry Kramer, who is the great gay rights activist who just passed actually about a week ago. He founded ACT UP, he founded GMHC, and actually the play The Normal Heart, I don't know if you've seen either the movie version on HBO or the play.
I haven't seen that.
It's a self-biographical piece that Larry wrote, and there's a character in it who's a lawyer, his brother, at a big law firm in New York, and that was based on Arthur Kramer. So in 1996, I go to Kramer Levine, and the first event for Summers was a reception in Central Park, and I really hemmed and hawed whether to bring my partner at the time. And I ultimately decided we were in church, and there was a gospel reading about something, I don't know exactly how it goes, but something to the effect that for a person to do what's right, even if that person suffers for it, if it's right in the eyes of God, it's the right thing to do. And I just started crying. My partner looks at me and goes, "What are you crying?" And I said, "You're coming to the reception."
That was your moment.
It was a moment of awakening, right? That I had to do this, as hard as it was. And so we went, and the first person to walk over I pegged him as maybe like a 65-year-old white male partner. And I thought, oh, this is not the first person that I want to have to introduce my partner to. So I was very careful. I introduced him by name, but not label. I didn't say this is my boyfriend partner. I just said this is.
And I'm sure people do that and still do that, and they're trying to get that momentum to be able to feel confident, in the outside world. And when I say outside world that is not queer, what I mean? To be able to introduce your partner, not just a friend, and it's hard for the heteronorm community to accept the idea.
It's also really hard in a law firm, because once I was comfortable enough to use a label, the label was partner, domestic partner, which we'll talk about. And in a law firm, when you say partner, it has a connotation that's business.
That's right.
And so it often confused people more. When I referred to my partner, they would say, "Oh, I thought you were an associate." I'm like, "Yes, I'm talking about my life partner." Anyway. So this old lawyer comes over to me, and I introduce Hector, and this man didn't miss a beat. He understood immediately, and he said to me, "Have you been involved with the firm's pro bono work? Have you met our pro bono coordinator yet? Because we are doing a case in New Jersey where this homophobic dinosaur of a judge wrote this awful homophobic opinion saying that the Boy Scouts could discriminate against a gay person because of their sexual orientation." So I was like blown away that this, again, like it was my own bias because I made an assumption that he was going to be conservative and stodgy and uncomfortable with it, and he was the complete opposite. And some of my friends said, did you feel typecast? Like, you know, that they assumed I would want to do this work just because I was gay. I wanted to hug him. I mean, I felt so welcomed and safe.
Right.
And I was like, okay, this is the kind of firm that I
you
want to be
a
at.
part of.
Exactly.
Yeah.
So that was my first work in pro bono work as a summer associate. It was the New Jersey case involving the Boy Scouts. And we were doing what's called an amicus brief. So an amicus is a friend of the court. So it's not directly a party in the case, but it's an important voice that helps the court
Decide. Okay.
And we were representing the American Psychological Association and some other social science organizations, explaining how homosexuality once was deemed a disease, a disorder, and how that had evolved, and there was an understanding that it's perfectly normal, part of human behavior.
That's right.
Remember, this is 1996, so we've come a long way. So back then, there was educating that had to be done. And then I left the firm to clerk for a court the next year. And the court happened to be the New Jersey Supreme Court, which was hearing that same case. It was years later, it had gone from the appellate level up to the highest court. So I disclosed to my judge that my firm had done this amicus brief, and he determined it was not a conflict for me to work. And I had taken a course at NYU Law School on sexual orientation and the law. And we had talked about sexual identity speech. What's unique about gay people, for the most part, is unless we say I'm gay,
That's right.
no one knows we're gay, right? And so what the Boy Scouts was arguing was...
Or unless there's something characteristics
obvious.
that
Yes.
are stereotypically associated
Correct.
with being gay, right?
Correct. But even then, people will make assumptions, but unless you choose to affirmatively say I'm a LGBTQ person, you know, people can make a stereotypical wrong assumption.
That's true, yeah.
And so this theory of study was, you know, the Boy Scouts said, we have no problem with this scout being gay. Our issue is that he talked about it. And if he kept it to himself, we would have had no problem. But once he starts, you know, indoctrinating and speaking, and so this theory is...
Just like it would happen in the military and how Obama had to...
Don't ask, don't tell.
Yeah.
Right, exactly. A similar thing to that. And so I talked to my justice about this, my judge, and said, you know, talk to him about this theory. And so after the court votes, I mean, this is all behind the scenes, the court voted unanimously to find it to be discriminatory, what the Scouts was doing. The judge then said, Norman, I'm prepared to concur separately on the theory that you shared with me. And a concurrence means he supports the ultimate outcome and the reasoning of the court, but wants to expand on that. And so I, you know, helped the judge write a 60-page concurring opinion that talked about identity speech in the context of LGBT. And so it was my first tangible impact in shaping the law around LGBT equality. It was amazing. So then I wound up, actually before going back to the firm, my firm had an opportunity to place a lawyer with a civil rights organization, Lambda Legal. We worked on a number of amicus briefs. There was the Lawrence versus Texas case. So that case struck down sodomy laws in the United States. And then I came back to the firm, and it was really interesting, Lambda, because it taught me, one of the things I thought I would do is go to a firm for 2-3 years, get some experience, pay off some debt, and then go into public interest, to go to a Lambda or an ACLU. And what was interesting about the Lambda experience is a lot of what Lambda did at the time was make decisions about the best impact cases to take on. And they were also very involved in the educational work. The actual litigating, they certainly did litigate, but a lot of their actual litigating, they relied on their cooperating outside lawyers to do.
Okay.
Because these firms have the resources and the human power to do it. So I found that doing pro bono work at the firm, to me, was more satisfying because you were lawyering. You were doing more of the lawyering as opposed to the policy work. So it was actually a lesson to me that I didn't necessarily have to leave private practice to go to a public interest organization to make an impact. I could actually
simultaneously do it both.
So I stayed at Kramer Levine.
And I was going to say, for those who don't understand sodomy, can we talk about
sure.
that?
So sodomy is any form of sex that is not heteronormative sex between a penis and a vagina. So if it's oral sex, if it's anal sex, you know, anything that is not the the norm
Right.
of a man and woman engaging in sexual intercourse.
That's right.
But the thing about sodomy laws is it's bad enough that you were criminalizing the very behavior that is the expression of intimacy for LGBT people. States took it further, and the federal government took it further, and the logic was, if you can criminalize, you can put someone in jail for the very conduct that essentially defines the class.
Mm-hmm.
Well, it's a lot less of a big deal to say you could fire someone for being gay.
Mm-hmm.
It's a lot less of a big deal to deny them rights and say you can't, have domestic partnership or marriage. If we can put you in jail for that conduct, it's far less oppressive to do these other things. And so sodomy laws were really used as a justification to discriminate against gay people in housing and employment and all kinds of other areas of law. What just happened? Yeah. So I think a lot of people don't realize in this country, I think a lot of people make an assumption if you're gay, you can't be fired. And while that's true in a lot of states, that is not true across the country. And the federal government, not long time ago, but in the 60s passed Title VII, which protects people from being fired based on race, based on national origin, based on religion, and based on sex. And there had been an attempt for a long time to, and it, by the way, did not include sexual orientation and does not include gender identity. And there have been efforts in Congress to amend the law over the years. The Equality Act has passed the House of Representatives before, but never made it to the Senate. The Equality Act would add sexual orientation and gender identity to Title VII so that you could expressly not fire someone or deny them housing based on their sexual orientation or their identity, their gender identity. But simultaneous with the efforts in Congress to amend the law, there have been legal arguments that have argued that the word sex in the statute is broad enough to include discrimination based on against gay people and lesbian people and trans people based on their sex. And the logic is, just to simplify it, the same man, if he were to come into the office and say he married a woman, people would celebrate that.
Right.
If the man came in and said I married a man, he could be fired for it. Well, there's an element of sex in that, right? A man, woman, man, man. It might also be sexual orientation, but it's not mutually exclusive. So as long as sex is one element of the discrimination, that's covered. So that argument was successful in two what are called circuit courts of appeal. Both of those courts, en banc is when the whole court rules, they determined that Title VII as written includes sexual orientation and gender identity. The Supreme Court of the United States took the case to decide it. And that's never a good signal. When you're an LGBT person and you see a positive decision that the court takes at the highest level, it makes you nervous because it's like,
it might be changed.
Right, why not leave it alone, right? And so we now, obviously with the Trump administration, have two conservative justices that were appointed. And there was a fear, because there was now a solid conservative majority in the court, that they would quash this theory and say, no, Congress has to do it, and we'd be in the same unfortunate situation we were in before, where gay people and lesbians and trans people were not protected federally. And so one of the interesting things is I actually watched the oral argument, and there was an old case from the 80s where the court had found sexual stereotyping was actionable as sex discrimination. It was a case where a man on an oil rig was perceived to be effeminate and therefore gay, and was mercilessly mocked by his colleagues and called names. They would graffiti his locker with fag and other kind. And the court found that extreme sexual stereotyping, basically attacking him because he was perceived as effeminate instead of masculine, that was actionable. And who wrote that decision was Justice Scalia, of all people, who was the most arch-conservative justice in the court, who has written horrific, scathing anti-gay opinions, but he's also a textualist, and he did an analysis that based on the use of the word in the statute, it was covered by the statute. And in the argument, I had forgotten that Scalia wrote that decision. In the argument, there was a lot of talk around that decision, and I said to Jovan, I'm like, actually, that's a strict constructionist who wrote that, someone who follows the text, Scalia wrote that might appeal to some of these conservatives in the court. And I was guardedly hopeful we might get a positive decision with Justice Roberts and Gorsuch in the majority, and Justice Gorsuch writing the decision, upholding the lower courts, finding that in the law as written, sexual orientation and gender identity are part of sex discrimination, and therefore gay people, literally as of
now.
This hour,
now.
are protected federally from being fired from their jobs in public accommodations. They can't be excluded based on their gender identity or being gay or lesbian. It's kind of amazing.
Yeah. We're going to read the definition for domestic partnership, because before there was marriage equality, there was domestic partnership.
Right. So domestic partnership, noun, a relationship between two people who live and share domestic life together but are not married. When I first started on the work around marriage equality, I didn't care if you called it bananas, as long as you gave the same rights to gay people in a relationship and lesbians in a relationship as you did to heterosexuals.
Right.
And Evan Wolfson, who was a real leader of the movement for marriage equality, sort of schooled me in the fact that the word matters. I mean, marriage in this country has a connotation unlike any other. If you're in the hospital and you're injured and you want your spouse to get in, you say to the hospital, that's my husband.
That's my
that
wife.
person gets in.
That's
You
right.
say that's my domestic partner, and the doctors look at each other and say, oh, do we have to do that? What's the status? Do you have a paper? Is it
It's
notarized?
questionable.
Right. And then there's an intangible around marriage, right? When you say this is my spouse, there's a status in that, right? Marriage is, and that's why it's called marriage equality. So there's no such thing as gay marriage and straight marriage. There's marriage. And LGBT people were denied entry into that cultural institution. And so that's why domestic partnership, it just doesn't cut it both legally, and I'll explain why in a second, but also just culturally. The other thing is domestic partnership, you can only go so far. So it gives you certain rights. It lets you let your domestic partner, for example, sign on to health benefits through your employer. But things like hospital visitation really depends on the hospital. Then there's other things that they just never could happen through domestic partnership. Inheritance. And there's a whole host of other rights around that only can come through marriage.
That's right.
Yeah, so common law marriage, some of that can happen, but domestic partnership, no.
Yeah.
Marriage equality is a noun. The concept of recognizing same-sex and queer marriage as equal to cisgender heterosexual marriage. The terms gay marriage or same-sex marriage can also be used. So gay marriage and same-sex marriage, we fought really hard as lawyers, because for lawyers, words matter, and we never in our briefs, never. It was like dropping an F-bomb in court.
Okay.
You can't say gay marriage or same-sex marriage.
Okay.
It was marriage for same-sex couples, marriage for gay people, because calling it gay marriage made it sound like it was something different.
You're right, words matter, and to have an insight on, the fight for this, I think that's really important for us to all know that, it wasn't something as simple as saying same-sex marriage. It was marriage for, because what is being prioritized and focused on is the idea of marriage. Okay.
And it's the same for everyone, right?
Yeah.
It's allowing gay people and lesbians to access this institution, which was so important to our society, and we were denied access to.
Yeah.
So we're not creating a new institution. We're allowing gay people into the existing institution. That's why it's marriage for same-sex couples.
Right.
And by the way, I didn't come up with this. I told you I would have called it bananas at the beginning. I had to be schooled myself in the importance of words. And from a legal standpoint, there are certain things that are deemed fundamental rights. And so in order for the government to justify discrimination in the context of a fundamental right, it's nearly impossible to do that. Marriage was deemed a fundamental right in our society. And so in the 1967, I think it was, Loving versus Virginia, which was a case so we had miscegenation laws in this country up until that time. So interracial couples could be put in jail for dating, and they could not marry. And in 1967, the most perfectly named court case ever made its way to the Supreme Court. Loving versus Virginia. It happened to be the last name of the interracial couple involved in the lawsuit, the Lovings from Virginia. And the Supreme Court struck down miscegenation laws because marriage was a fundamental right, and the government did not have a compelling state interest to deny that right to interracial couples.
Right.
And that case was a cornerstone of getting gay people the right to marry.
Thank you so much for sharing with us. This was really insightful.
It was my pleasure.
Such a proud moment. Like how I did that.
Ba-dum-bum.
Dun-dun-dun. We're proud during Pride Month. Thank you so much.
Can't wait to have the Queen's English on the coffee table here.
It's coming. Woo! Thank you so
Thanks,
much.
Thank you.